a repurchase calculation will help us understand how much money do you get back in your lemon law case. Do you get back all of your money, less than all of your money, or maybe more than all of your money back? My name is Sina Rez Law. Not only am I a huge car fan, but I also happen to be a lemon lawyer who loves making content. So if you are interested in learning more about the lemon law, learning more about your legal rights, or learning more about cars, make sure to subscribe for more. Today, we will be doing an in-depth dive into a repurchase calculation for a lemon law case. Now, before we dive in, it's important to note that we will be doing this repurchase calculation according to California law. Every state has its own lemon law, and some of them have different nuances. So just keep in mind that this calculation may be a little bit different in your home state. Let's take 2 steps back to talk about what is a repurchase, otherwise known as a buyback. If you have a lemon, in other words, a defective vehicle, then the lemon law says that the manufacturer needs to buy back your vehicle. In some situations, you may be able to get a replacement, but the most common option is a buyback, also known as a repurchase. Even though it's called a repurchase, there is no consideration of what the fair market value is. Really, a repurchase is a refund of your money. So it would be fair to assume that you're going to get back all of your money, right? Not exactly. The lemon law allows for some deductions, and the lemon law sometimes allows for you to get extra money back. So a repurchase calculation will help us understand precisely how much you will be getting back in your lemon law case. Before we start crunching the numbers, let's talk about, in theory, what someone should be getting back in a lemon law case. Essentially, we start by assuming they're going to get a refund of their money. That could include things like your down payment, if you had a trade-in that was worth something, your trade-in value, all of your monthly payments, which include principal, interest, and tax. We also add in other incidental damages. These are things like paying for a tow truck, reimbursement of rental expenses, or if you had to pay for a repair, we include that as well. But by law, the manufacturer is allowed to take certain deductions, the most common of which is a mileage deduction. The mileage deduction is sometimes also referred to as a usage deduction or a mileage offset, but it all means the same thing. The manufacturer is allowed to withhold some money because you likely got to drive your vehicle for some amount of miles before it became problematic and before you had to take it to the dealership for repair. Let me give you a little example to help explain this better. Really quick, if you are getting any value out of this video, then go ahead and give it a like. Let's say that you had a vehicle that the first day you drove it off the lot, it had problems and you had to bring it back in for repair. In that situation, there should be no mileage deduction because you didn't get to enjoy the car at all before it became problematic. But let's contrast that with a vehicle that became problematic at 40,000 miles. That person got to drive their car for 40,000 miles before it became a lemon. And that's why it's fair for the manufacturer to withhold some value in that particular situation. In addition to those amounts, the manufacturer also has to pay off the vehicle. That means if there's a loan, the manufacturer has to pay the bank the balance that's owed on the car. The manufacturer also has to pay your attorney's fees and costs, so you don't have to pay anything. Now that we've outlined all the basics, let's dive into a real life calculation. To do a repurchase calculation, we need to look at a few things. We need to look at the purchase agreement or the lease agreement. We also need to look at the repair orders, especially the earlier ones. We also need to look at documentation that supports any incidental damages like your current registration, any rental receipts, tow truck receipts. Here we have a retail installment sale contract, also known as a purchase agreement. For starters, we're going to find out how much did our client put down and did they have any trade-in. To do that, we'll scroll down to the second page. At the very bottom, in section 6A, we can see that there's a description of any trade-in vehicle, which there is none. And in line 6G, down here, you'll see that our client put down $30,000. I know in this case, we don't have a trade-in, but oftentimes we see people with trade-ins where there is negative equity. By that, I mean that the person that traded in the vehicle actually owed more money than the car was worth. So for example, let's say that the car is worth $25,000, but they owe $30,000 to the bank. Essentially, they are trading in a vehicle for negative $5,000. That negative equity gets factored into the repurchase calculation. Next, we'll want to understand how much is this person paying per month and how many payments have they made. To do that, we'll scroll up to the top where there is a summary. Here we see there are payments being made for $782.36 starting in October 26th of 2021. As of today, that means that our client made 29 payments of $782.36. Now let's better understand how much our client has in incidental damages. This particular client does not have any tow truck expenses, no rental expenses. So really all there is his current year's registration. By taking a quick look at the registration, we see that he has paid $882. So we'll add that to the calculation. So we now understand all the money that went into the vehicle. Next, let's take a look at the deductions or the offsets that are going to apply. To start, we'll calculate the mileage deduction. To do that, we'll need to understand how many miles did this car come with. By looking over here, we see that it came with 28 miles. Now we'll want to identify what was the first major repair with the vehicle and what was the mileage at that repair. So now we have the very first repair order for this vehicle, and we could see that there were some major issues with the engine overheating. The mileage at this repair was 11,033 miles. Now we'll take a final look at the purchase agreement to understand if there are any dealer options that need to be deducted from the calculation. To do that, we'll look at the second page, starting with line 1D. This is a summary of any theft deterrent devices, also known as alarms. And in this particular case, there are none. Next, we'll look at line E, where we see surface protection products. Here, there's one line item for $1,495. Next, we'll move down to line I, where we see a description of 3 service contracts. One is a Mopar extended warranty for $4,400. One is maintenance for $2,795. And one is a tire and wheel package for $987. A quick note on service packages: while they are a deduction from your lemon law case, you are allowed to cancel them and get back a prorated refund for the unused portion from the dealership. Last but not least, we will look to see if there is any debt cancellation agreement, which would be in line K, also known as gap insurance. And here there is none. Now we've taken a look at all the different line items that will be included in a repurchase calculation. One thing that doesn't apply in this particular case is a civil penalty. But a civil penalty is when the manufacturer has in some way mishandled your case and they have to actually pay a penalty on top of the compensation that you're entitled to in a normal repurchase calculation. Civil penalties are a way that many of our clients actually get back more money than they paid for their car. So on paper, our client should be getting back just over $38,000. So we let our client know the calculation and we asked them if this seemed accurate to them, if there was anything that we missed, just to get feedback to make sure that everything was accurate. Our client mentioned to us that the dealership that he actually bought the vehicle from went out of business. So he was asking, how can I actually get back a refund for these service contracts when there's no dealership to go back to? That was a great point. So we actually went back to the manufacturer and we told them that they need to waive all of the dealership offsets. And they agreed. That meant that our client got back nearly $10,000 more than the repurchase calculation would have first indicated. Hopefully now that you've seen an actual repurchase calculation, you can better understand that it's not so simple as just getting all of your money back. That definitely can be true. And many times our clients are actually getting back slightly less than the full value that they paid into their vehicles, but also an equal amount of times our clients are getting back more money than they spent on their vehicle because of the civil penalties that I mentioned earlier. I'm hoping this walkthrough was helpful for you to understand how much you may be entitled to in an actual lemon law case. If you happen to have a repurchase offer from a manufacturer, or if you have any questions about the lemon law process at all, please follow the link in the description below to get in touch with our team so we can help you out. My name is Sina Rez Law. Thank you for watching. If you have any questions at all, go ahead and drop them in the comments below. And if you want to watch more, go ahead and click here.